This is a closer look with the monitor. I'm Craig Blumenshine from Prairie Public. A ballot measure headed for the November election is now facing a constitutional challenge that could stop it before voters ever see it. The issue centers on legislative term limits approved by voters just a few years ago and whether lawmakers overstepped their authority by placing a new measure on the ballot that would loosen those limits. Joining us to discuss is Mary Stoyer. She's a government and politics reporter for the North Dakota Monitor. She's been following the lawsuit now before the North Dakota Supreme Court, and she'll help us understand what's being argued and why it matters and what could happen next. Mary, welcome back to Main Street.
Thank you.
Mary, let's start with the basics. What's the lawsuit about and who's bringing it?
So the lawsuit accuses the state legislature of undermining a 2022 term limits constitutional amendment. And the main impetus of the lawsuit was a resolution that the legislature adopted in 2025, Senate Resolution 4008. And that resolution sort of followed the constitutional amendment that passed on the ballot and included some little tweaks that the legislature wants to refer to voters to approve in November. So the plaintiffs of the suit are two men who were on the sponsoring committee of the term limits amendment. They helped put that on the ballot. And they are former lawmaker from Minot, former Senator Ole Larson, and then a Grand Forks County Commissioner whose name is Terry Bierke.
We'll get into exactly what Senate Resolution 4008 tries to do here, but take us back to 2022. What did voters approve? What did we approve when we passed the original term limits amendment?
That amendment, Article 15, makes it so that state lawmakers can serve no more than 8 years in the House and 8 years in the Senate. And when it passed on the ballot, it passed with 63% approval from voters. The whole idea behind it is to try to keep people from spending decades upon decades in the legislature and to encourage a more diverse set of people, maybe younger generations, to join the state house and hopefully make the legislature a better place.
Mary, what was your feeling on why those term limits were significant in our state at that time now, almost, 4 years ago?
There's a sort of tension between the legislature and the public who supported the amendment, because although few people have come out against the idea of trying to encourage new people to join the state house, there's a concern that the limits will push institutional knowledge out.
Institutional memory. We hear that often. Sure. Go ahead.
Yeah. And then not really provide incentives for new people to come in. We have a citizen legislature, so it's really hard to get people who have the resources and the time to join the state house. So there's some concern that it'll push people who have a lot of institutional memory to contribute out the door without really having adequate replacements for them. And then lawmakers had some heartburn about the very strict 8 years in either chamber rule too.
So walk us through then Senate Resolution 4008. What are those tweaks that you talked about just a moment ago that are trying to be made?
So the changes don't change the net amount of years that lawmakers can spend in the legislature, but it does say that they don't have to do up to 8 years in the House and up to 8 years in the Senate. It allows them to spend those 16 years wherever they want. So they could max out 16 years in one chamber and then spend no years in the other, or, they could do 12 in one and 4 in the other, etc. And then another change is that they specify that incomplete terms or partial terms don't count against your term limit.
So if I were, say, appointed midterm or came on midterm, it was only when I would be elected again, or maybe for the first time, would my clock start?
That's my understanding.
And all of this, Mary, was it your feeling was because of this worry that institutional memory was leaving the North Dakota legislature?
Part of the resistance or the anxiety, although The other part was just to like clarify potential ambiguities, or lawmakers perhaps felt that the 8-and-8 rule was an unnecessary restriction.
All right, let's get to the core constitutional dispute. If we can, the lawsuit argues the legislature violated the Constitution. What specific constitutional language are the plaintiffs now pointing to?
There are two different provisions that they accuse the legislature of violating. The first one, I think, is the most obvious one, which is that in Article 15, I should say, it specifically says the legislature cannot propose a change to Article 15 messing with the term limits. And so the plaintiffs in their complaint say, well, this resolution specifically proposes a change to an amendment that the amendment itself says shouldn't be possible. Therefore, we're bringing this to the Supreme Court. And then the other one is in a different part of the Constitution. It says that when a policy change is approved on the ballot, the legislature may not amend that change for 7 years unless they clear a 2/3 majority in both chambers.
Lawmakers and legislative council now say the resolution is constitutional. What's their argument?
Their argument, although they haven't filed a official response in the lawsuit, their argument is that, well, the language of Article 15 conflicts with something in the Constitution that's older than it. So elsewhere in the Constitution, it specifically says the legislature has the power to refer policy changes to the people. And so they, it's hard to think about how to phrase this, but I suppose they're making the argument that that part of Article 15 itself is unconstitutional, or at least is clearly in conflict with a different part of the Constitution. And then when it comes to the other provision they're accused of violating, when I spoke with legislative counsel, they said even though there's that provision that says the legislature can't change stuff that passed on the ballot for 7 years unless they clear the 2/3 hurdle, they say that referring a potential amendment to the ballot doesn't count as making a change. It's just sort of providing the option to the public to make the change.
I'm Craig Blumenshine, and you're listening to A Closer Look with the Monitor. My guest is Mary Stoyer. She's a reporter from the North Dakota Monitor, and we're talking about a potential ballot measure headed for the November election that's now facing a constitutional challenge, and that could stop it before voters ever see it. And it has to do with term limits. And we'll continue our discussion relative, Mary, to the role of the Secretary of State. What role does he have, and why does his office still approve the measure for the ballot?
I talked to Secretary Howe about this, and he said that under state law and some court cases where the Supreme Court has ruled on this area previously, the role of his agency is to just certify ballot proposals when they meet the general requirements and not really try to gatekeep what may or may not be constitutional. So he basically said, there's no reason why his agency should be involved in any capacity other than that. Like, it's just their job to put it on the ballot if it meets the ordinary requirements.
We'll let the Supreme Court and others decide whether or not it's actually constitutional. What are the plaintiffs asking the Supreme Court in reference to time to act, and why are they asking them to act very quickly?
They want the Supreme Court to prevent this proposal from getting on the ballot, or I believe in their complaint they also said if that doesn't work for whatever reason, to not count the votes, or render the measure of no effect in whatever other appropriate capacity. And so they're calling on the Supreme Court to hopefully take up the case and review it rather quickly, since the general election is coming up later this year.
What options does the Supreme Court have, Mary, at this point?
To speculate, I think they could probably dismiss it outright, or maybe even say, we don't think we're the right venue for this, take this to the district court level, or they could take it up and review the case. Um, the other question to consider is, will the Supreme Court answer the question of, is that provision in the Constitution in Article 15 in direct conflict with other parts of the document? When I was talking to Representative Ista about like his take on it, he basically said like he wants them to answer that ultimate question, but courts are very hesitant to decide those issues when they don't have to. So they could figure out a way to deal with this with the case, but also kind of sidestepping that part of it. So they could do a lot of different things, and who knows where
Mary,
they'll take it.
since the lawsuit was filed now, legislative leaders have voted to hire outside attorneys to defend the state. A little unusual. What prompted that decision?
So they met earlier this week to decide that, and when I talked to Senator Hogue, the majority leader, he said, well, they want their separate attorneys to handle this case since it's an important constitutional issue potentially, and they want to make sure the legislature has dedicated people to handle it. And even though that meeting, when they were talking about the case, they were in executive session, so we unfortunately don't have the luxury of knowing exactly what they were thinking. But the other part of it could be the lawsuit is against the legislature, but also the Secretary of State's office. So maybe they wanted their own special people to represent their specific interests if they felt that their interests are distinct enough from the Secretary of State's office.
Mary, you pointed out that Majority Leader Hogue called part of the 2022 amendment a direct encroachment, and that's a quote, on legislative power. What did he mean by that, and why is that argument important to the legislature's case?
I think he's worried that if this amendment in full is upheld, that could potentially allow for future constitutional amendments to take away other powers of the legislature. So I think the legislature is really, or at least the supporters of that Senate Resolution 4008 are really interested in kind of defending their ground, because they feel that the amendment, Article 15, is sort of chipping away something that they felt was supposed to be theirs.
Mary, Representative Zach Ista was the lone vote against hiring outside lawyers. What were his concerns, both legally and then also fiscally?
So he voted against Senate Resolution 4008. He made it sound like he didn't want to get into this from the start, but he did say he wants the Supreme Court to kind of answer the question here of like, who's right. The other thing is that he said that from the standpoint of having competent attorneys to represent the legislature's interests, he said, why hire outside counsel when legislative counsel or the folks at the AG's office would probably do the best job out of anyone in the state, since that's kind of their territory. So he said that would be, in his view, that would be better and also less expensive. And then he also said that he didn't feel like the legislature's interests in viewpoint in the case would be substantially different from the Secretary of State's office. So he just felt it was an unnecessary step to go hire additional people.
You know, from a practical standpoint, this hiring to me seems, the hiring of outside counsel, as though it's a signal about how seriously lawmakers expect this case to be contested. Do you agree with that?
Reading between the lines of what people have told me, that sounds like that's probably right.
Does this at all, the hiring of outside counsel, change the timeline we talked about before as to how quickly and whether the Supreme Court would take the case up?
I don't know. I think that I feel like it's probably all up to the Supreme Court to decide that timeline. If they're going to take the case, and then, you know, they probably have a lot to say as to if they want to take it up, how quickly it would proceed.
Is it unusual, Mary, for the legislature to hire outside attorneys in a dispute that pits the lawmakers directly against a voter-approved constitutional amendment?
That's a good question. I don't know because I can't think of another time when the lawsuit was over a constitutional measure itself. And that might just be my own lack of
Institutional knowledge,
institutional knowledge. Although, like, I feel like I know that it's very common for the state to hire outside counsel for litigation, and that includes like constitutional lawsuits, like the lawsuit over the abortion law, and then also the transgender care case, and so on. So, but yeah, that's a good question. If anyone knows, I'd like to know that too.
That's Mary Stoyer. She's a government and politics reporter for the North Dakota Monitor, helping us unpack a lawsuit that could shape both the November ballot and the future of legislative term limits here in North Dakota. You can always read Mary's full reporting and her colleagues' full reporting at northdakotamonitor.com. And of course, Mary, we're appreciative of your time with us today. Thank you.
Thank you.
A closer look with the Monitor continues. We now bring in Amy Dalrymple. She's the editor-in-chief of the North Dakota Monitor. That's North Dakota State's newsroom outlet. She joins us periodically on A Closer Look with the Monitor to share what she and her team are working on and to highlight the stories readers should be watching at the Monitor. Of course, you can look at the Monitor, as we've said earlier, anytime at northdakotamonitor.com, where there are no paywalls and no subscriptions required. Amy, welcome back to A Closer Look with the Monitor.
Thanks for having me, Craig.
What else have you and your team been working on, Amy?
Well, this week, Monitor journalists had the opportunity to participate in a training with the Secretary of State's office to learn how to navigate a new system for financial disclosure forms and campaign finance reporting. One thing that's new this year is a requirement for elected and appointed officials to file a statement of interest once a year rather than once every 4 years. And the deadline for those filings is January 31st. So many of these documents are already online, and we got to learn a little bit more from the Secretary of State about how to access them. And then we also learned that for folks that are running for office right now, they have until April 6th to file these documents.
So what is different about these new requirements? Certainly they're more regular now. And what problem do you think, Amy, is this new requirement trying to solve?
Yeah, there was some new legislation approved in 2025 that I believe was trying to address a concern that the public sometimes has about conflicts of interest among the elected or appointed officials. And so this legislation just improves the transparency so that anyone can take a look and see what sort of financial connections their elected appointed officials might have. One of the other things that's different with that legislation is that previously these forms were only available if you made an open records request. And so in my experience, if you were just asking for one or two statements, the Secretary of State's office would routinely scan that document and provide it at no charge. But there could be a fee, especially if you were requesting multiple documents. Our experience was ahead of the 2024 election when we requested at the Monitor the statements of interest for all candidates who were going to be on the November ballot. We had to pay $170 to obtain that information. And we also were unable to get it electronically. So we ended up with a lot of stacks of paper. And so the big change for the public and also the media is that now we'll be able to access that information online for free, and you don't have to make an open records request.
And you can find that information through the Secretary of State's website, which is sos.nd.gov. And of course, with technology and transparency that we all expect today, it's kind of high time that this be done. Amy, what do these financial disclosures show?
They're usually like 3-page documents. They're pretty short, but they show the principal source of income for the official and their spouse. They also show some other financial interests and any boards that the official and the spouse serve on. It also has a new requirement to disclose some financial relationships that they may have with government agencies.
All right, Amy, what else is the Monitor working on?
Yeah, we're turning more of our focus to 2026 election coverage. We're hearing candidates making some campaign announcements and other officials announcing their retirements. So we're going to continue to track that news as we head closer to the state political conventions.
2 major retirements just this week, the House Majority Leader and also the House Appropriations Committee Chairman. So yes, lots for the Monitor to cover. That's it for today's A Closer Look with the Monitor. Our thanks to Amy Dalrymple for sharing what's ahead for the North Dakota Monitor. And you can find new episodes and follow along every Thursday here on Main Street and at Prairie Public, and every Friday at northdakotamonitor.com or wherever you get your podcasts. Talk to you soon, Amy.
Thanks, Craig. Talk to you next week.